Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with my friend Omar the Tilted Lawyer and my friends Bruce from Oregon and Schnitzel Ninja. You guys have probably, if you've been watching for a while, seen all of them here at some point. But I gathered everyone here tonight because I cannot bear to read my own filing in this case. So I'm going to have some friends do it for me.
Oh, God.
Yeah. Oh, God, exactly, dude. I was thinking, I was like, should I have Omar on here? He might hate it. But
I mean, I pre-approved it, so sort of.
did you? I didn't know if you had time, so I was kind of like, all right, whatever.
Well, I read it, I scanned it in 30 seconds. Like, yeah, do that. I was like, file it. This thing is great.
I mean, that's about my approach to things these days. So I think that's solid advice. Anyways, I wanted to mention some people in the chat were saying as well. Before we get started, that tag list, a list of people who were in communications with the agency group.
Has it grown?
And that was the dispute. The agency group was a former crisis PR group that worked for Justin Baldoni at some point for a little bit during or after the immediate aftermath of the film marketing and like when all that drama stuff was going down.
Yeah.
And they implied, Blake and her counsel implied, that we were all on a list that they disclosed in Discovery. That we worked at the behest of Wayfair to produce content that was negative about Blake Lively. What actually happened, as we learned either yesterday or the day before, was there was one person from the social media subpoenas that was identified on that list, and that was somebody who made a routine request for comment, as somebody from the media does. It was a larger YouTube channel. It's not a weird thing to do. And that I happen to know for a fact that that is somebody who has asked for comment or participation at some point between all parties. So it's not just the Wayfair parties. So. And today that was finally unsealed because that was an attorney's eyes only provision. I guess that list of content creators that tag had been in contact with. And as the Wayfair parties said, there was one name, that person I just mentioned, on that list. Just of people who had communicated with them, aka asked for comment. And people have been kind of trying to burn a lot of us at the stake because there is 45 content creators or journalists or whatever you want to call it at some point in the last week or so that have been implicated in this imaginary smear campaign. And there was one person from the social media subpoenas that was listed in those disclosures. So that was intentional. It was an intentional misrepresentation of the facts, I felt like. To make us look bad, to implicate us in this smear campaign. And this is the first time I've ever been on the weird receiving end of a conspiracy theory. And I'm just kind of like, I've never talked to TAG. I've never talked to any publicist involved in this lawsuit. And today kind of confirmed that, which is interesting because now I'm seeing what it's really like when conspiracy theorists are confronted with the facts. And it's a hard cope. So I'm I'm on the receiving end of some weird theories right now, but I got to tell you, it feels a little good to be.
So what would you
say
you learned here?
I mean, just be careful with the way that lawyers word things, I guess.
Lawyers are dicks. I think that's like the overarching lesson.
You say that a lot. And the thing is, like, the people that I have in my life who are attorneys, and that's a lot of my closest friends. Like, you're one of my closest friends. And then I have people in my personal life that they're not YouTube people, so I don't really talk about them, but they're attorneys. And they would never do what these people are doing. So attorneys are dicks, yeah, but some of them aren't, you know?
Yeah, some of them aren't, but the ones that are not, you don't hear about those. The ones that you deal with, the ones that you have to oppose, the ones that you have to litigate against. Those
are the only ones that I give a shit about.
And those are all dicks. And then the best of luck.
I'm saying the only ones that I care about are not dicks. They're really great people. So.
Well, I erased what I said.
So Lauren, I have two questions for you.
Yeah, what's up?
If you're ready.
Yeah, go ahead.
Number one, did they send subpoena? So this list is now, you've seen this list of the list that only had one person, you know. Okay.
Right.
Did they send subpoenas to the other people in that list?
So the list of the 4 people they identified, it was Perez Hilton, which they did subpoena Perez. Andy Signor is the one that was identified, and Popcorn Planet. He did the documentary. He's been totally transparent about this. He was one of them. Candace Owens was the third, and fourth was Billy Bush. So 3 out of the 4 of those received individual subpoenas directed to them. But Andy happened to be the only person who got a regular subpoena served to him, as well as the Google subpoena. So she made it sound like people in the social media subpoenas, as they're calling it, were on the tag list, when really it was just Andy who got a routine request for comment.
So my two questions are, why didn't all the people on the tag list get subpoenas? It sounds like only 4 did. That's number one.
Right.
And number two, where did you come from? Like, are you on some list? Like, why did they do these social media subpoenas? That's my second question. Like, where did you guys all come from?
We came from nowhere. The thing that we have in common is that we have all spoken negatively or unfavorably, or in some way just like talked about Blake Lively in a way that she didn't like in this litigation, or in the immediate, kind of preamble, I guess, leading up to this. So that is the only common denominator.
So here's my conclusion, and tell me if I'm right. They had a list of like 60 people, and they subpoenaed 4 of those.
42. No, 43, sorry. And then plus Candace and Perez is 45 if you include the
So they had some big tag list, and they subpoenaed only 4 of those people. And didn't subpoena the rest.
Let me pull up the tag list, because...
Is that correct?
It'll make sense. Hang on.
I have maybe a little lag, so sorry.
They have... No, you're good. You're good. They have a list of people on here. But when they were asked about content creators, there were only 4, I believe. But we're going to find out real quick.
Okay, so Tag had a list of 60 contacts or 40 contacts or whatever, but they only sent subpoenas to 4 of those people, correct?
3. Of the contacts on that list, they sent them to 3, but only 1 of the people from the social media subpoenas was on there.
Right.
And that was
then the other subpoenas they sent out weren't on any lists that anybody's identified. Is that correct?
Correct. Yep.
So this is very strange.
But they implied that we were, and that was intentional. It was a really bad PR move, because they thought that Wayfair and Tag, because the client list or the contact list for public relations firms, as they established in the very beginning of this case, that's protected information. It's attorney's eyes only. They thought that they would fight that. And Wayfair said, no, fuck that. We want to disprove their allegations that there's some kind of smear campaign with content creators, so we're just going to let it be unsealed.
No, I get all that. I'm asking subsequent questions like...
No, I was more saying that for like people who are, watching, but...
Oh, yeah, for sure. And based on that, what can we learn? It seems very strange that they would have a larger list and make a few subpoenas from that list, and then subpoena a bunch of people that weren't even on any lists.
Yeah. Give me 1 second.
It's very odd.
I have to go back in the docket here, 51 or something. Yeah. So, here we go. That's not it. Hang on. Share this tab. Okay, so here's the tag list. And I think it is number 5 that we're supposed to be looking at, but we'll look at all of them just in case. Yeah, no, it's response to interrogatory number 5. Okay, responding party incorporates by reference its general objections, blah, 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 blah. So they're saying it's like overbroad. They don't, on the grounds that it's vague about communicated, because people are saying communicated means worked at the behest of, basically. But the actual list of people is right here. It's 4 people: Billy Bush, Andy Signor, Candace Owens, and Perez Hilton. So, and she implied that all 45 of us were on this list, and we.
How on the basis of that do they send you a subpoena?
That's what they're saying. The basis was,
That's what I'm trying to get to, Omar. Like, so there's not even a list of like 60 people or 45 people or anything. No. There's a list of 4.
And that's it.
It was a last ditch PR attempt.
They subpoenaed 3 of these 4. Yeah. Is that true? 3 of these 4 got subpoenas. And Andy,
as far as we know, Billy Bush has not been subpoenaed. Yeah. So
Andy gets the 2-for-1. He gets twin subpoena. He gets the twins.
Not the twins.
And then okay. And then we don't know where the rest of you came from. Cassidy and you and everybody and Lee.
Bitterness.
We know exactly where we came from. It's people who don't believe Miss Lively was sexually harassed by Mr. Baldoni.
Oh my gosh. This is unbelievable.
It's like Omar, she can't possibly believe that people don't believe her or people don't like her.
Correct.
Well, I'm just curious about all the I don't know what you would want to call it, misrepresentation or miscommunication. Have you ever seen this kind of thing, Omar, where it's like, here's a list of 4 people, and then 42 subpoenas go out?
Well, I've gotten subpoenas like that, and I would tell them to kiss my ass. I ain't complying with shit. If you don't withdraw it, I'm going to do a motion to quash and ask for sanctions. Fuck off.
Can you imagine if that's all your motion to quash said?
It's literally what I did. And then they just removed it. It's like, yeah, that's okay. And then we just whittled it down. And they came to their senses because it's stupid. Like, you give me an offer of proof why you need a subpoena. This has nothing to do with the case. And then, I would threaten them with a motion to quash and sanctions, or they could just withdraw it and, try again. And they just withdrew it. It was fine.
Well, I mean, I asked for the offer of proof. And then at that point, they were like, okay, we can meet and confer at your convenience. So I told them, and I'm not going to talk too much about the meet and confer process, but I will talk about the evasiveness because I already wrote it in the filing. I was like, okay, my convenience basically is what I said. I didn't say it like that, but my convenience is like, I have these days available this week. And I told them what time zone I was in, like they asked. And then they refused to respond for like a week. And then so I sent a follow-up with the same questions that I was like, hey, you still haven't answered these questions. And basically I was thinking, like, in light of the tag interrogatories that we now have more information about, why are you choosing to subpoena my information? Other than I have, expressed my, my protective or lawful free speech to say unfavorable things about Miss Lively. No real answer until like late last night. I didn't even see it because I was so busy working on this stuff. And then early this morning, I turned it in. And then I get another email from them, I guess, a little bit after that, where they're like, we saw you filed a motion to quash. Like, we want to meet and confer. And I said, okay, well, I'm working until 6 today, so I can't really do that. It's a little bit late, maybe Monday. They wrote back, we can meet at 6. And I was like, dude, when I say 6, I mean, I work to 6:30. So I said, Monday is better for me. What time? And then, of course, they stopped responding again. So I don't know what the deal with that is. People are saying, like, don't meet and confer with him. No, I'll do it.
I think it's required that you got to at least make the attempt. But the fact is, you also have a deadline.
I do not. They do.
Yeah. So. You have a deadline. And so if they're just going to play games, then you proceed. I mean,
I don't have a deadline anymore. It's already done. So.
Oh, well, how about that?
Gosh.
Yeah. All right.
Omar, shouldn't they have done a meet and confer activity prior to filing a subpoena?
If you're going to file a subpoena, no. But
No?
I would assume they would at least have an offer of proof to issue the subpoena. And if they do, then they don't need to ask anyone's permission. They could just subpoena somebody. What they can do is meet and confer after it's already been issued, and either just tell them, have a conversation. Look, this is all I'm looking for. If you give me this, I'll withdraw the subpoena. This is all I need to see. Or comply with the subpoena, whatever. Why? Because I've connected the dots because something, and I need this information. They're not doing that though. And they misrepresented that they may have based this off of discovery responses received from the Wayfarer parties. Turns out that's a load of horse shit. And so unless they could tether some other kind of offer of proof to all of the other subpoenas that are not from the 3 named on that list, then these are easy motions to quash. I don't suspect that the judge is going to allow this to stand. I just don't.
So your process is an offer of proof, then a subpoena, then if there's questions from either side, you have a meet and confer. Is that the correct?
Well, the correct way to go about it is, like, they've done discovery, and so they get a list, and they're concerned about smear campaigns. Great. Give me every content creator information that you've communicated with about this case since such and such date, whatever. Then you take that list and you subpoena those people. What you don't do is just start subpoenaing people at random that you have no basis to subpoena. That's inefficient. Right. At best, it's inefficient. And so they're kind of going about it backwards. I'm just going to subpoena 60 content creators at random on the suspicion that they may have had communications with Wayfarer. No, man, you're allowed to fish. You're not allowed to fish like that. There's a much less intrusive way to do it, and which is the way that I suggested.
Yeah. So the correct process here, if TAG gives them this list of 4 names, they should file 4 subpoenas.
Yeah.
Because and then if there's questions about those subpoenas, then you have a meet and confer process.
Right. Exactly. Like, if you got a basis to subpoena something, just issue it. Like, why waste time? It's easy to withdraw. It's easy to meet and confer, but it puts them on notice that you're looking for something. What I won't do is just start abusing the subpoena process, which is what they appear to be doing.
Mm-hmm. All right.
Thank you.
So we'll get into the, I'm not going to read that first part. Hang on. But we'll get into the memorandum here. But I'm going to have Snitzel Ninja read most of this because I cannot read my own fucking filing. It's embarrassing to me. People say that like when content creators get dragged into this, they call it like legal warfare, or like litigation warfare or whatever. I don't know what they call it on YouTube. You're supposed to make content out of it and like make money and stuff. I'm just like, I'm so uncomfortable reading my own shit. Like I can't help it. So like I was like, I need friends. So
I'm not uncomfortable reading my own stuff.
I know, but that's because you're a lawyer and you have to do that. So
yeah, I like the sound of my own voice. I like the sound of my written words as they're read on a page.
I mean, I don't not like your voice or your written words. I'm just saying mine are a problem for me. So I'm going to be in the live chat, but I'm going to have, like I said, Snitzel Ninja read most of this. If you want to stop and talk about it, you can ask me questions and I will answer them. Otherwise, I'm just going to be talking to the people who are watching, and I will be the scroll bitch like I was before.
Oh, God.
All right. So we'll start here.
Pages, Jesus, Lauren.
Most is like the 30 pages of subpoena.
Oh, the
so
attachments? Okay.
Yeah, we're not gonna have to worry about that. All right. Let's you want to start here, Snitzel at the top?
Please take notice. Okay. Please take notice that non-party Lauren Neidigh Movin respectfully submits this memorandum of law in support of her motion to quash the subpoena issued by plaintiff Blake Lively to Google LLC, commanding the production of certain documents. The subpoena dated July 3rd, 2025, internal reference number 100884180, seeks personally identifiable information and private data associated with Movement's YouTube account at Lethal Lauren 904. Additionally, Movement respectfully seeks issuance of a protective order barring further abusive discovery by Ms. Lively without prior court approval. Introduction. This motion to quash the subpoena refers to the subpoena served on Google LLC seeking private information and data of 16 YouTube creators under the premise that they are engaged in a smear campaign against plaintiff Blake Lively at the behest of the Wayfarer parties. Exhibit A, the subpoena, targets creators who have expressed unfavorable opinions about Ms. Lively online. The subpoena is not supported by any evidence. It serves to intimidate, harass, chill constitutionally protected free speech, and threaten the safety and privacy of non-parties who are not involved in this litigation. Ms. Lively has offered no reasonable explanation for why she believes Movement's criticism of her is inorganic. Counsel has been uncooperative or unresponsive upon Movement's attempts to meet and confer. Ms. Lively's counsel would only state that Ms. Lively brings claims against the Wayfarer parties in part on the basis that they engaged in a digital media smear campaign by planting negative stories about her in the press after she reported sexual harassment on the film It Ends With Us.
That is all they ever told me before I filed this, by the way.
That's crazy. Ms. Lively has issued subpoenas seeking information about accounts that posted such information or otherwise engaged with that content to determine whether the Wayfarer parties played any role in its dissemination. Exhibit C. Movement attempted to confer to determine how her personal information and private data could possibly fit into Ms. Lively's smear campaign apologue, given that Movement did not even begin discussing Ms. Lively's case until after the lawsuits were filed, and Movement's coverage of this case relies upon publicly available court filings or public information that has already been disseminated by legacy media outlets. Ms. Lively's counsel ceased responding upon requests for further explanation. Thus, the subpoena appears nonsensical. For example, it is unclear how Movement's backup email addresses and login history could have contributed to Ms. Lively's turmoil over the public's negative response to her decision to hawk alcohol and hair care products while promoting a film about domestic violence. There is no reasonable connection between Movement's login history, the Wayfarer parties, and Ms. Lively's public relations plight. Ms. Lively is unable to explain why Movement's private personal information and data are relevant to the litigation at hand.
Hey, folks, I hate to do this. I got to run.
All right.
My sincerest apologies. I'll catch you all later. Have a good weekend.
Bye.
All
You
right.
too.
Have a good one.
This attempted excavation of private information and data and refusal to cooperate in
Sorry.
meet and confer efforts is an abuse of the federal government as a mechanism to confuse, embarrass, and punish lawful expression of unfavorable opinions of Miss Lively by private citizens who cannot afford to hire counsel to entertain Miss Lively's wild theories about an untraceable smear campaign. It is undeniable that Miss Lively's own words and actions influenced Movement's negative opinion of her, as this is well documented through Movement's YouTube coverage that Miss Lively is apparently already aware of.
I mean, she has to be, otherwise I wouldn't be here, you know?
Right. The Wayfarer parties had no hand in influencing this opinion, as they never attempted to contact or persuade Movement to speak unfavorably of Miss Lively. Movement's subjective, personal belief that Miss Lively has made false allegations against defendant Justin Baldoni has only been reinforced by the fact that Miss Lively has now also brought false allegations of smear campaign involvement against Movement and Movement and several other content creators and or social media users across various social media platforms, including a YouTube channel that had just one subscriber at the time the subpoena was served.
That's a true story.
Despite her insistence that there is an untraceable smear campaign, Miss Lively never seems to any difficulty at all. Have any difficulty at
Yeah,
all?
so I left
That's
a
a-
word out there and it's gonna haunt me for the rest of my life.
Oh no! Oh my god! Not a big deal at all. Seems to have any difficulty at all identifying the targeting, those whom she believes to be the perpetrators of this phantom campaign. Miss Lively's unwillingness to accept that the public's criticism of her is genuine has now gone so far as to become a public safety hazard. It is a threat to the general public's privacy and constitutionally protected free speech so long as she is allowed to pass out subpoenas for the private information and data of whomever displeases her. Should the public engage in lawful speech that is unfavorable of Miss Lively, she may continue to attempt to use her counsel's subpoena power to force the public into time-consuming, distressing, and unaffordable litigation to defend their own reasonable expectations of privacy. This desperate attempt to penalize Movement and other citizens for their lawful speech should be hindered by the court, as it is a fruitless and meddlesome inquisition and embarrassing misuse of the justice system. 2. Factual background.
All right, we can pause there for a second. I
Okay.
feel like this is like every comment I ever wrote about David Gingras. Like, seriously though. God, like, what an embarrassment. Oh my god.
He never subpoenaed us.
No, I mean, there's still time, I guess, before he goes to jail, but we'll see.
Oh man. Does your audience know who he is?
Some of them do. I want to say it's like 30, 70 probably. Most of what I do is this stuff these days.
Mhm.
So, but
He's a great lawyer. Google him.
Yeah, he's the best. If I have to get a lawyer, I'm definitely getting David Gingras.
The
He's
Conor
not
McGregor
otherwise
of
tied up.
litigation, right?
Yeah. Okay.
Just don't contact him on the 31st because he has an arraignment for a DUI.
Oh yeah, he's very busy next Thursday.
Okay. 2.
Right.
Factual
Yeah,
background.
go ahead.
Movement is number 5 of 16 independent online commentators identified in the subpoena. Movement purchases federal court filings from the Pacer website and lawfully analyzes these court filings and publicly available material related to this high-profile litigation. On or about July 10th, 2025, Movement received notification from Google that her identifying information, including names, emails, addresses, IP logs, payment data, and other personal information, was sought via the subpoena in this action.
So I was in a hotel in LA when that happened. And
God.
yeah, I was in a hotel in LA and I get this email and I was like, I texting Omar, or like I was in like some kind of group chat with Omar and I think Rachel. And I was like, hey, by the way, Blake Lively just subpoenaed me. And I didn't know what it meant at first. So I was like, is this even real? Like, what does this mean? What does she want? and like it didn't give very much information, so they kind of didn't know either. But then there was that whole back and forth between a whole bunch of people about, is this even real? Which was a whole debacle, just like getting them to confirm it was a real subpoena. And of course, Andy from Popcorn Planet, his lawyer called Ezra Hudson's office, the attorney for Blake Lively, and they were either like saying, no, it's not real, or we don't think so. Which, if you issued a subpoena for this information, you know.
Right. I remember him playing a call, like of him
Right.
calling the office and asking.
Yeah.
And that's actually really important, because if there's so many scams and phishing attempts with email, right?
Right.
One of
and
the
that was
things
the
they
thing.
actually,
Everyone's like, it's a phishing attempt. So
exactly. One of the things they tell you to do, like in corporate training about phishing scams, right? Because corporations don't want to lose their private data. They say, look, go independently. If you get a thing from your bank, don't click the link in the email. Go independently call your bank.
Yeah.
So what Andy did was correct. He independently called the law firm to independently verify the information. And that's why it's so disappointing that he got the runaround like that.
Right.
It's crazy. It's like, did they really not know, or were they told to like just shut up and don't say anything?
It sounded like the receptionist was told to shut up and not say anything. The
that's
receptionist
that's
was
the
told,
feeling I got
Ezra
too.
said this. Ezra said to take a message is basically what she said. And I can't remember the exact wording on that. But Ezra knew, because Ezra was the one who served the subpoena, or issued the subpoena.
And I wonder if they didn't realize they were going to get all this backlash for doing that.
Well, they got away with the Van Zandt thing, which I don't know if you really know anything about that, but yeah, okay. So they got away with that. And I wonder if they thought that they were going through some sort of channel that would make it so that we did not know they were seeking our information. And people have said like they were going after people they thought were bots, but I'm clearly a real person. And I, am a person who makes human mistakes and shit like that. So there's no way they didn't know.
I'm a real person.
Right, yeah. Shut up. But yeah, so that's not it. There's just it's kind of like, even if they can come up with a creatively worded explanation for that, it's like we all know that they knew. Like, it's just that they can maybe get out of trouble by saying or explaining it away somehow, but it's like, they knew better than that.
Yeah.
There's no way these smart big firm lawyers did not fucking know they served a subpoena. Yeah.
And I mean, they've already shown with the other one that you mentioned that they're a little snaky and trying to do things
right
in a shady way. But that's still probably legal, but they don't want to be like forthcoming about it.
Right. All right, we can move on a little bit. Where are we at?
The subpoena at the top line there. The subpoena issued by Miss Lively's counsel, Ezra Hudson, requests the following from Google. A. Names, addresses, email accounts, and phone numbers, including backups. Despite heavy implications by Miss Lively's counsel, Movement was not contacted by the agency group TAG, or, God, 2 tags in your life, or any of the Wayfarer parties to smear Miss Lively at their behest. Exhibit B. If Miss Lively wishes to collect information on journalists or social media users who have communicated with the Wayfarer parties, this information should be requested directly from the Wayfarer parties rather than a witch hunt for every account on social media that may have engaged in commentary about Miss Lively that she does not like. B. IP addresses, login histories, and geolocation data. Miss Lively has not explained, nor is easily apparent, why Movement's locations have any bearing on this litigation. Despite traversing multiple states and continents since beginning her YouTube coverage of this litigation, Movement's unfavorable opinions of Miss Lively and expressions thereof have remained the same. Miss Lively has further not explained why she is seeking this information from as far back as May 2024, when Movement did not begin speaking about this topic until January 3rd, 2025, after Miss Lively's lawsuit was filed. Movement can assure Miss Lively that she was quite busy working multiple jobs while also attending online classes from May 2024 to January 2025 and was not doing anything that would be relevant to Miss Lively's litigation. C. YouTube and Google Pay account information, including payment sources. YouTube neither directly pays their creators nor do they use Google Pay. No third party has access to add additional money to a YouTuber's monthly pay. Movement is paid by AdSense according to ads run on Movement's YouTube channel. Movements. Oh my God. Furthermore, Miss Lively herself makes a compelling argument that individuals have a constitutional right to privacy regarding their financial information. In her response to the Wayfarers Party's motion to compel Miss Lively to disclose her own financial information in litigation, she elected to initiate and seek damages. She states, quote, "This argument falls woefully short of overcoming the general rule against seeking party assets and financial information and Miss Lively's constitutional right to privacy of the same," end quote. Do you want me to read the footnote?
The footnote from the last page. Now you're good because we're gonna come across that. But anyways,
You have
Okay.
footnotes, Lauren? This is fancy.
yeah, I know, right?
Oh, it says CDKT number 421.
Yeah, I thought you were talking
Okay.
about that one, but we're good.
Okay, cool.
So this right here, this came mostly from Cassidy and Leanne, the Google Pay part of it. I did not write most of this paragraph, just wanting to give credit where credit is due. Leanne Newton and Cassidy O'Connell helped me with that a lot. So
Awesome.
Yeah.
There was a little bit left. Do you want me to read the rest up there?
yup. Go ahead.
Okay. They're right there. That's great. Miss Lively appears to recognize the basic elements of privacy rights that individuals are entitled to, despite her attempts to pierce the privacy rights that others are equally entitled to. I think her problem is she doesn't see other people as equal to her.
No, absolutely not. Never. No.
It's disgusting to
Yeah.
me.
Yeah.
And no one paid me to say that.
I did. AdSense did.
D, bank account and credit card information. It is bemusing to imagine that Miss Lively sincerely believes Movement's credit card information would be relevant to the claims in this litigation. Credit cards are used for purchases and not for payments. Miss Lively's counsel has refused to offer any details to explain why they seek this information despite multiple attempts to discuss the issue. Exhibit C, Movement gathers from the limited available information that Miss Lively believes Movement I'm going to say it like 20 more times.
That's
Movement is being paid by, someone outside of AdSense to create content about Miss Lively. The opposite is true. Movement pays for the official court filings from the Pacer website with her own money and provides commentary on these filings on her YouTube channel of her own accord. It costs Movement money to make her own content.
Yeah, so I put that bill in like the attachments to the declaration, which we haven't gotten to yet, but and I was like, this is embarrassing because people are like, why don't you get it off the free websites or whatever? I was like, no, it was an investment. Like at the time this was all breaking out and people were like talking about this like hourly every day. I was like, I need to beat the tabloids. I need to get there faster than these people. So I was using Pacer. I wasn't using
Yeah, and it's your
smaller
prerogative
websites,
to
right?
use it.
And I mean, it paid off in the fact that like my platform grew a lot to the point that it kind of offset the cost for at least a little bit. And then it still cost me money, but at the same time, it's like it paid off substantially. So
And
I
it
was like, I
can
wouldn't
be
pay it back.
expensive to run a YouTube channel.
Yeah.
This request for Movement's financial records is highly invasive, unfounded, and inappropriate. Miss Lively should request information on any communications or payments between the Wayfarer parties and the media or social media users directly from the Wayfarer parties themselves. Miss Lively should not be given free rein to invade and extract the private financial information of those who speak unfavorably of her online. She has no business obtaining the private financial information of Movement or other non-parties with whom Movement shares a bank account. Movement fails to see why information such as bank account numbers would be required for any other purpose than to issue a further subpoena to the financial institutions with whom Movement conducts her business to obtain fuller financial records which have no relevance to Miss Lively's claims and are grossly intrusive. There is no reasonable explanation or evidence to show that Movement's financial information would be relevant to Miss Lively's litigation.
So that's like, what else are you going to do with my bank account information? Like my bank account number and my bank. Like, what are you going to do with that? Obviously,
Right.
you're going to go subpoena the bank. despite the fact they don't want to answer the question. That's obviously what you're doing here. So,
and the problem with that is even if you do that, it's not a sufficient action, because if you use, I don't know, your Chase account to deal with YouTube, and they get your Chase account, maybe you have a Wells Fargo account or US Bank account that you use to surreptitiously deal with Wayfair. So they may not even know about that account.
right.
So
Exactly.
what they're doing here, they don't even have a basis for sufficiency in what they're doing.
Bruce, while you're talking, I might have missed why Bruce is constantly in a van, but why is he? Do you want to explain that one?
I have to have a reason? What?
Apparently, man.
Why
I don't know.
not?
I mean,
People
I
need to
can't
know.
be in my van. What the heck? Oh my gosh. I mean, I could live stream from the restroom. I don't know.
I wish you would not.
Just the middle of the woods.
That's
I'm
a
on the
lot.
loose. I'm living the van life. It's a choice.
Oh my god.
Loose moose.
All right.
Okay. E-subscriber registration data, premium services, and account usage history. It remains unclear what this entails as far as Movement's subscriber registration data or what premium services have to do with any part of this litigation. This request needs clarification. However, as noted above, Ms. Lively's counsel was uncooperative with the meet and confer process during which Movement would have sought to discuss the issue further. It cannot be determined with certainty whether Ms. Lively is seeking the information and data solely of the Movement, or if she also seeks the data of users who subscribe to Movement's YouTube channel. While it would usually seem common sense that someone would not seek the data of everyone subscribed to a non-party Movement's YouTube channel, this is no longer a common sense determination, given Ms. Lively's increasingly unreasonable demands to invade the privacy of others. Ms. Lively has no reasonable basis to obtain Movement's data to further a paranoid investigation into others who speak unfavorably of her online or subscribe to channels that do so. Ms. Lively's overbearing requests for Movement's private information and data are overly broad, highly intrusive, and completely without merit.
I'm sorry. Of the subpoena Van Sham thing got me.
That's funny. Miss Lively cannot offer any evidence to explain or support these requests. The only reasonable explanation for Miss Lively's pursuit of Movement's private information in this manner is because Movement speaks unfavorably of Miss Lively and favorably of Mr. Baldoni online. Movement formed her own opinions and has not acted at the behest of any of the Wayfarer parties or the Lively parties for that matter.
And there's still time, Call me Ryan.
me.
Yeah.
I feel like I'm mispronouncing movement
You're not
when I
moving.
say movement so many times.
You're good.
My brain is like, that's wrong.
Rather
Miss
you than me.
Wait, what?
I said rather you than me.
Miss Lively has been misleading in her representations of social media users' involvement with the Wayfarer parties. On July 18th, 2025, counsel for Miss Lively, despite refusing to answer questions or clarify the reasoning behind the information sought from Google, submitted a motion to compel, in which she heavily implied Movement was among a list of creators working at the behest of the Wayfarer parties via tag as part of the alleged smear campaign. Miss Lively's counsel represented to the court and the public through creative wording that Movement and others targeted by the subpoena were named by tag in their June 25th, 2025 interrogatory, right? Responses that were designated attorney's eyes only. Exhibit B. This is patently false, as Movement has never spoken to anyone from tag. And the Wayfarer parties confirmed that just one of the 43 users targeted by subpoenas to Google, X, and TikTok, the social media subpoenas, appeared in tag's interrogatory responses. Furthermore, the context in which that user appeared was misrepresented. Footnote 3. Miss Lively's motion was a manipulative public relations tool which served only to traduce Ooh, Movement. Nice. And the other social media users who have been targeted by the social media subpoenas. Ms. Lively's weaponization of the legal system will continue to serve to harass, intimidate, and potentially bankrupt non-parties who are completely irrelevant to this litigation if Ms. Lively's overly broad, invasive discovery requests are not hindered by this court.
All right, we're going to skim over this part with the legal standard and the argument. I don't want to go through because it's mostly just boring ass shit. Nobody wants to hear that. Okay.
That sounded like a good footnote, that last footnote. I don't know.
Oh, it's in the exhibits. You're good. So we'll start here.
Okay. 5 requests. So just to like give people like a little idea of what you just went through. So it's legal talk for why it should be quashed.
Why this shit is dumb. Yeah.
Okay. Great. 5 requests for protective order. In addition to quashing Ms. Lively's subpoena to Google, Movement requests that the court enter a protective order under Federal Rule of Civil Procedure 26C, prohibiting Ms. Lively from issuing any
Rule 26. I know.
From issuing, I'll never hear that number again the same way.
Finally got a good Rule 26, guys.
Look at me, Daddy.
It's not on my bingo card.
I think this one is legit.
Amazing.
It directed at what?
No, keep going.
Oh, sorry. Okay. Ms. Lively from issuing any further subpoenas or discovery requests directed at Movement, other non-parties, or related private information without prior leave of court. Rule 26C authorizes. Leave of court. Rule 26C authorizes the court to enter an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden of expenses. The subpoena in this matter is overbroad, invasive, and constitutionally problematic as it is seeking sensitive financial and location data from a non-party speaker in connection with expressive activity protected by the First Amendment. The use of civil discovery to compel such disclosure without adequate justification or tailoring suggests an abusive strategy with a chilling effect on public speech. To prevent future misuse of the discovery process and to safeguard the privacy and expressive rights of Movement and other non-parties, the court should require Ms. Lively to seek advance judicial approval before pursuing any further similar discovery efforts. Word.
And this is just asking for sanctions. Basically, if I decide to retain an attorney, I would want attorney fees and costs. Also, it seems like this was issued in bad faith or for an improper purpose, so it's asking for that as well. So we'll go to the conclusion here.
Okay. Conclusion. Ms. Lively's subpoena to Google fails on multiple grounds. It is shockingly invasive and overly broad while lacking any reasonable basis for seeking the private data and personal information of Movement and other non-parties. There is no evidence to suggest that Movement has engaged in a smear campaign at the behest of the Wayfarer parties, despite Ms. Lively's misguided notion. Ms. Lively's abusive subpoena is particularly concerning, considering her own recent comments. Propounding herself an advocate for women and girls' safety, she stated, quote, "I see so many women around, afraid to speak, especially right now, afraid to share their experiences, and fear is by design. It's what keeps us silent," end quote. Footnote 4, she's a dumb bitch. Miss Lively's attempts to chill free speech through these
That's not what I wrote.
No, she didn't. I added that, sorry. Through these intimidating subpoenas is troubling in this context. As a survivor of abuse who understands the paralyzing fear that can come from traumatic experiences and make it feel impossible to speak up, Movement is concerned about the precedent that could be set if Miss Lively's attempts to scare and silence dozens of women on social media are allowed to continue. The right to free expression extends to all women, even to those who say things we do not like, and even to those who do not like us. Hurt feelings are not a valid legal basis to infringe upon the rights of others. Movement objects to Miss Lively's attempts to obtain her private data and personally identifying information, as it is intrusive and useless to Miss Lively's litigation. If Miss Lively insists upon questioning Movement's non-existent involvement in a smear campaign and can somehow manage to come up with a valid reason to continue involving Movement in these affairs, then Miss Lively is free to have Movement deposed under oath to confirm that Miss Lively is wrong.
All right. Well, we're gonna skim over this part because it's pretty boring too. But let's see. This is the subpoena exhibit A, which is like we're not gonna read that because we've all seen it. I know Bruce has definitely seen it. So this is the letter motion that they were, implying that Tag named us in their interrogatory responses, and that's why we were subpoenaed. As we know, that is not true. And then C was the emails. Let's see. I mean, I'll show you the questions that this is public documents anyway, so what does it matter? But it was like me trying to follow up a bunch of times, basically getting no answer for the first 3-4 days. And then eventually they started writing back. But
this is interesting. Did they respond only after you said you plan to file a motion to quash?
So they sent me let's see. So they sent me this on the July 14th, and I got the subpoena on July 10th.
Okay.
And it said, "We understand Google may have provided you notice of the subpoena, blah, blah, blah." Then I said, "I intend to file a motion to quash in this matter." And that was the next day, I think. Yeah. And then they were responsive saying, "We will discuss at your convenience." We went back and forth like twice, I think. And then they kind of ghosted a little bit. Then I filed that notice of intent, and they started responding again, which is why they said this part about which I quoted in the filing there. Miss Lively brings claims against a Wayfarer party as the basis they engaged in a smear campaign, which has nothing to do with me. And it's fictional, so it doesn't fucking matter. The last thing I said was, let's see, over a week ago, I did not cover this lawsuit or your client at all on my channel until after the official court documents came out. The only reason I did so was because I was a fan of your client's work. I was therefore interested in her lawsuit. On my own, I came to the conclusion I do not find Miss Lively's version of events to be credible. The vast majority of what I cover on YouTube is the public court documents. I often read them aloud and share my thoughts in real time. Otherwise, I'm primarily reading public information from popular news outlets. This is well documented. Why was my account chosen? What do you intend to do with my credit card or bank account information? How are my IP addresses relevant to your litigation? That information is very private, and I do not feel you have reasonable grounds to access it. And then, of course, they did not really respond to that. So almost a week
They
later,
didn't reply to this one?
later, they did not respond to that. 5 days later, I said, I want to follow up. And this is after a couple days ago, after Wayfair came out with a letter that said, no, they were not listed in tag interrogatories. I said, I would like to follow up on these questions. I basically just copy pasted. And then I didn't hear from them still until, I guess, late last night. They sent me an email, but I didn't see it till this morning.
And what did that say again?
They said, you want to meet and confer tomorrow. But like by the time that I saw that, it was already tomorrow. You know what I mean? So
Right.
I was like, dude, I'm working. Like I'm not an attorney. I work for a living.
Yeah.
The attorneys work for a living, but you know what I mean? Like this is not my job. I'm
Right,
doing this
right.
on top of my job. So I was like, no, dude, I can't until like I'm not off till 6 p.m. today. And then they said we can meet at 6, and I was like, dude, Monday, because when I say 6, I mean 7.
What do you think? What do you think they want to talk with you about?
I'm not going to speculate on that at the moment.
Okay.
I know lots of people are talking about that, but that's personally something like because these are already in an exhibit, so I don't mind talking about them. But as far as the actual, if I decide to meet with them,
I don't know, and I think that and I actually haven't heard anyone else. I haven't heard coverage of anyone else talking about this, but to me, it seems like they're afraid to have your motion to quash granted, and what precedent that's going to set for all the other content creators.
Well, they, they just made a really big blunder in the PR department, bigger than this thing in general, which is just a terrible blunder. But like, they made a big blunder accusing us of being on that tag list. Basically, it seems to me like they were bluffing and they didn't expect tag to release that list. And then when they did, it's just like, oh shit.
Which is
So,
awesome. I mean, I think that's awesome that they did, and they're like,
Yeah.
okay, well, here it
Right.
is.
because people who like when you know you haven't done anything wrong, it's like it's hard. Like you don't want to let people cross your boundaries and like give your private information away, attorney's eyes only information away. But at the same time, it's like, well, I kind of want to, and I'm not talking about me to them right now. I'm just saying in general, I kind of want to stick it to you by telling the truth. You know what I mean?
Yeah.
So I feel
And
like
you
that's
have
probably how that went. Yeah.
and there's nothing else to tell because it is just truth.
Yeah. This is the last.
So
bit
Lauren,
of
in all the email communication you've had, it's all either, to me, it seems like it's all logistical. Like, hey,
Mhm.
maybe we could chat or something. Or
Yeah.
there was that one email where what did they do? Copy and paste something from a filing with the vague accusation about the smear campaign. Is that
Mhm.
right?
Yeah.
And that's all they've sent you an email for all of this?
Yeah, I mean that's pretty much it. I mean I showed you all the emails I got except for the one I got this
Yeah.
morning, and the response to that, which was like, we can do 6 or we can do Monday, and I was like Monday, and then nothing. So that
Yeah.
was it.
It's just disappointing. It's also sort of vague and perfunctory stuff about scheduling something. Like it's let's get to the
Yeah.
point, right?
Yeah, I mean, it's been difficult. I mean, but I also want to be transparent and like this is what this is going to be like for a lot of people if this becomes a precedent. So it's going to be a struggle. You're going to have to people who have kids and jobs and everyday lives, or if this becomes a precedent and it cannot afford an attorney retainer, are going to have to kind of go through all of this, go through these motions, and they're going to make it difficult for you. And so this should not be a thing. This should not be allowed. So, all right. I will read this because it is because I'm talking as myself in this rather than referring to myself in the third person, which I felt really weird about, by the way. All right. The first time I discussed this legal dispute between Blake and Justin was January 3rd. Prior to that, I was aware of the speculation of a rift between Miss Lively and Mr. Baldoni, but did not cover this on my YouTube channel. Prior to Miss Lively's CCRD complaint being filed and the New York Times article being published, I did not know much, if anything, about Miss Lively or Mr. Baldoni outside of their respective career works. I was aware that Miss Lively was married to Ryan Reynolds, who I was a fan on. So, I watched, Blake obviously in Gossip Girl, because I've seen Gossip Girl like 3 times, maybe 4 times. And I was seeing their like snarky, sarcastic comments to each other, Ryan and Blake, and I was like, oh, they're funny. I like them. So that was the extent of my like being a fan. It wasn't like I wasn't like a huge, huge fan. I was like, oh, I like them. So that was kind of like that. I didn't really know anything about them personally.
And I've never seen Gossip Girl.
Dude.
I'm sure as hell not going to watch it now.
No, I would still endorse the show.
I haven't
to be
seen
honest.
it either.
I would totally still endorse the show. Do it. I became interested in this case because I was a fan of Miss Lively's work on Gossip Girl and The Shallows. I want to point out that doesn't necessarily mean I knew anything about her as a person. I just liked her work. So, and I saw there was an increasing number of people online who were discussing Miss Lively's past behaviors. I felt this criticism was unfair, as these behaviors occurred several years ago, and I do not believe that past mistakes, statements, or behaviors always reflect one's character in the present. So I had to go back and watch that, guys. When I first started talking about this, I was like, oh, this is terrible. Because I was like sticking up for her so much. I was like, I was going on this rant about how it's like not right to be mad at somebody just because you don't like them over like one thing. Like, oh, she used the T word, which is what she did. It was like, but if it was someone else that you did like and they did it 10 years ago, you wouldn't mind. So I was like going to bat for her so hard. I was like,
Taint?
No, but I'm not gonna say it, am I?
I know you're not. I know.
Yeah. But yeah, so I don't know. It was hard to watch because I had to watch that all back to do this. So like, damn, like just put
That's
the
the
mic down,
double
lady.
T word.
Huh?
Taint tattoo.
Oh, sir, I don't know what you're talking about.
It's in a filing.
What?
The taint tattoos. Yeah.
Oh, yeah, okay. Anyways. You could just said that. I started my coverage of this case on YouTube with an open mind, reading Miss Lively's original complaint against Mr. Baldoni and the Wayfarer parties, as well as related articles on popular news sites. I openly expressed my discomfort over the harsh judgments online of Miss Lively's previous statements and behaviors. As I continued in the early stages of my coverage, I specifically stated that my stance on the issues between Miss Lively and Mr. Baldoni was aggressively neutral. And unfortunately, I really did say that. After carefully considering Miss Lively's complaints and the statements made to the press by her attorneys, as well as the legal filings and statements by all of the parties involved, I determined that I did not find Miss Lively's version of events to be credible. This has been presented as my subjective opinion, and I have named my channel coverage the Court of Random Opinion to reflect my views as such. Most of my opinions and YouTube videos are based on the federal court filings in this case, which I have purchased on my own from the Pacer website. One needs to look no further than the hideous quarterly Pacer bill attached in the exhibits of this filing to confirm this. Based on what I have learned through my coverage, I personally do not believe that Miss Lively was sexually harassed by Mr. Baldoni, and I personally do not believe there was a coordinated smear campaign against Miss Lively. I arrived at these conclusions on my own without contact with any of the Wayfair parties, any of the parties, either parties, I guess, involved in this lawsuit. I have shared this personal subjective belief frequently on my own social media platforms. I have a monetized YouTube channel, but I do not receive payment from any other social media platforms. I have chosen to exercise my First Amendment rights to free speech on my platforms when discussing this high-profile public interest case. Ms. Lively need not pay attention to it if she does not enjoy listening to my opinions, especially as I have blocked Ms. Lively and Mr. Reynolds on social media. True story.
Old.
Despite what is... I mean, I did. Despite what has been heavily suggested by Ms. Lively's attorneys, I have never communicated with Melissa Nathan, Jennifer Abel, the agency group, or any other publicist involved in this lawsuit. I have never been offered payment by any of the Wayfair parties, their publicists, or their counsel for any reason. I have never acted at the behest of any party or counsel involved in this lawsuit. I have reached out to attorneys at Liner, Friedman, Tadelman, Cooley, LLP, LFTC on 2 occasions. That's Justin Baldoni's attorney, Brian Friedman, his law firm. On 1 occasion, I made a request for an interview with Mr. Baldoni. I was not plotting with LFTC to influence the media narrative about this case, as I specifically noted that the subject of the interview would be his Baha'i faith, and that the interview would not be related to the lawsuit at all. I did not receive a response from LFTC, which was not surprising. I mean, I was just some rando. On the other occasion, I contacted LFTC. I asked for clarification related to the court's docket, as Mr. Friedman was temporarily no longer listed as an attorney for Wayfarer. LFTC left me on red again. I later learned that Mr. Friedman's temporary absence from the docket was only due to a filing error. I would prefer not to disclose these one-sided communications to LFTC, as my relative inexperience in journalism at the time led me to proceed like an utter dork. It did not even occur to me that I should contact a publicist rather than an attorney with these requests. That said, if I am given no option but to embarrass myself by disclosing these emails in the interest of protecting my privacy from Miss Lively's invasive subpoena, I will do so. And again, true.
So they do have a publicist you can contact for interview requests?
Yeah, tag the people I never talked to, like tag and whoever Jen Abel works for now. I guess she has her own practice now.
I didn't know if they were still connected. I don't know if they were still working on the... I know, but
yeah.
Oh boy.
AKA the cat lady. I guarantee Lauren will get that interview with Justin after this is done. After the subpoena crap, I fucking better. Oh my god, man.
Hey, you got to take shots to make shots, right?
I really would have foregone that, to be honest, just to not be in this position. But it is what it is, I guess. Yeah, so some people who are like really in the conspiracy theory camp that I was mentioning earlier saw that I wrote, I contacted LFTC on 2 occasions. And even though I described that at length and like made it very clear that they never responded, they're like, see, they're admitting they had, or she's admitting she had contact, and she's admitting that Ms. Lively has a reason to blah, blah, blah. I was like, no, it is not a civil or criminal offense to speak to someone, even if the other party involved in the lawsuit with them is not liking them. Like, no. Especially if it's like a media request, even though it was like a media request from somebody who was clueless, it's still a media request, you know? So all I did was ask for an interview, and I asked for a comment or clarification, whatever.
Yeah, that's why I've always been disappointed with this language of like coordinated smear campaign, right? Yeah. Or communication. Yeah. Like if I hit the like button, am I communicating with you? Like how? If we have a bunch of phone calls, that's clearly communication, but they're not specific enough in terms of what their basis is before they filed these subpoenas, which I think is, you know, where Omar was going at the beginning.
Yeah.
So that's always something that's bugged me. It's like, okay, if you send an email to someone and they never reply, is it communication? I mean, I don't know.
Yeah.
Laura would say it is.
Yeah, I mean, turn those email trackers on, right?
He read it.
Oh God. All right. Let's see. I have only attempted to communicate with Miss Lively's attorneys regarding the subpoena. They were largely unresponsive, as everyone has now seen. To this day, it is unclear why Miss Lively seeks my financial information and other private data. If Miss Lively is eventually seeking to use this information to then subpoena my bank, she would only learn that I am very financially irresponsible and that my expression of my thoughts and feelings about Miss Lively's accusations against Mr. Baldoni has not been financially backed by any of the Wayfair parties or their counsel. My financial decisions, including my exorbitant Pacer bill, though I have characterized them broadly here, are private. I do not believe Miss Lively has grounds to launch an expedition into my personal life using the federal court. I do not find it appropriate for Miss Lively to fish through my private data and information of any kind, given that it will not reasonably lead to any evidence to support her claims. I do not consent to Miss Lively obtaining any of my information from Google LLC, as I believe the subpoena was designed only to harass, intimidate, and punish my free speech. And then, of course, there is the Exhibit A, which I avoided showing anyone until today, of the $2,274 I paid in Pacer bills to make my content. So, yeah.
I mean, it seems like if they're looking for bots, they need a better tech guy or something, because they're not doing a good job at differentiating between real people and bots.
Yeah.
At least from all the videos I've seen on this case.
And if they had even had someone review, go to this channel and check it out and see if it seems like a real person, then they obviously, like you said, would have seen that you're a real person.
Yeah.
Mm-hmm.
Yeah, if they had an intern or two, they could have just watched Lauren's channel and bypassed all this nonsense, maybe.
Switched sides.
All right.
Well, I think that was all very well written, and I'm very proud of you.
I mean, thank you, but I'm very bad at that's what I'm saying earlier, the self-promotion stuff. I'm just kind of I know you're supposed to make content out of this to make a mountain, a good thing out of a bad, like a lemonade out of lemons or whatever. But I'm dude, I'm too embarrassed to do that. So I was somebody help me.
But you can talk. You can talk about the thing that you couldn't before if you want to.
Oh yeah, that's right. So our friend Mike is being dragged back to court by the serial fake pregnancy scammer Laura Owens. Laura accused my now friend Clayton, who was a lead of the show The Bachelor at one point, of impregnating her with twins after a blowjob. And it turns out she's been scamming dudes with this kind of shit for a decade. So half of whatever we raise from tonight, I'm going to put towards Mike's legal fund, and then the other half is going to go towards that Pacer bill. So yeah, we couldn't talk about that earlier because I wasn't sure if I was supposed to or not. So
yeah. And there's a stream tomorrow.
I'll be there. Yeah. 6 p.m. tomorrow. Yeah. 6 p.m. Eastern.
So I wasn't sure if we were talking about all that earlier until
you should because my mind is blank right now. You should say whatever you want.
No, that's it. Okay. if you are moved by the abuse of Blake Lively in all the many forms it has come in that we've seen, please go donate to Mike Maricini.
Yeah, Mike is, gosh, and Mike doesn't have the resources of a Justin or a Wayfair, you know what I mean? Mm-hmm. So that sucks.
Yep. Yeah, he's tried to fight this woman in court before. He spent $50,000 to fight her, and long story short, that didn't work out.
Right.
And so now she's trying to renew this phony DVRO for permanently for the rest of the time.
Yeah.
And he needs some help. He needs some help financially supporting that.
Yeah. And she didn't only fake the pregnancy with Mike, she also faked cancer and a bunch of other things.
Yes.
I firmly believe that she faked being in a psychiatric hospital, but
It's so funny because she says that in one of her declarations for the DVRO, she says that she did not claim to be in a psychiatric facility. She claims that the police came, her parents called the police, and the police came and took her to the ER, and she got fluids. And she spoke with a psychiatrist about changing her med dosage.
Mm-hmm.
But we've seen the texts, and that's not exactly what she says is happening.
Right.
Yeah.
Yeah. Right.
There's just so many. There are hundreds of those things that she's claimed
So
one thing in one
yeah.
place and then another thing in another.
We're gonna have to
Yes,
read through
one-
those texts another time for people who are new here because they're interesting.
Yeah.
And the terrible.
Lauren,
way.
do you know tomorrow's stream? Are you going to be broadcasting that on your channel, or is there a different channel people should go to for the
Megan
fundraiser
Fox.
stream?
Megan Fox, who was on my stream at some point last month. Let's see if I
don't
can-
think she has a link up yet, but you could link to her channel, of course.
I can find out. Let's see. Why not?
Yeah, I think there's a lot of parallels between this case you're talking about, the Owens v. Eckerd case, and
there it is. That's kind of how we
this-
ended up here.
at least where we are today. Maybe not at the beginning, but where we are today with all of these subpoenas and this overreach in terms of using the court system to do things that maybe you haven't built a foundation yet to proceed, or you haven't proven your claims yet to proceed in court. We've seen similar things in the Owens v. Eckerd case, like we have here in this Lively Baldoni case. And I think it's an interesting pair of cases to compare and contrast.
For sure.
And yeah, maybe a recap video or something showing some of the good ramp up videos that people could watch about the Owens v. Eckerd case. For example, there was that podcast that was, what was it, a 3-part podcast recently that was pretty good for a recap of the thing. And then Caitlin Bristow's interview with Dave was another good one.
Right. Yeah.
There's a couple ways where you don't have to watch 50 hours of stuff to get an overview.
Well, I mean,
of
I'm
the case.
not a huge Nick Viall fan, but Clayton's interview on Nick Viall was, I liked that one. So.
And I have a recap video that, God, I don't even remember when I put it out, but it was before he was indicted. Right. So it's not completely up to date.
Oh, nice.
All right, let me read some of these. Millennial Mom, thank you for the 20. I love you. Shout out to you, Leanne, and everyone fighting this bullshit, combating lively fun. Thank you very much. I appreciate that. Vipan, thank you for the 5. I'll tell Omar because Omar had to leave, but if time permits, Omar, do you think Popcorn Planet can get into legal issue from the documentary itself, or can a disclaimer protect them? I'm gonna hang on. I just screenshotted that so I can ask him. All right. He's probably not gonna answer right now, but thank you, Vipan. I'll relay that to him. Tea Drinker, thank you for the 20. Amazing job, Lauren. Here's to help with your Blake's account fund. I mean, your legal fund. I mean, they're the same fund, I guess. Thank you. Ellen, thank you for the 20. Eloquent motion to quash. Amazing work. All this content creator is now part of a new story. The Sisterhood of the Traveling Subpoenas, authored by Half Baked Blake. Thank you very much. The Mouse's Ear, thank you for the 5. The motion to quash have been one amicus briefs that states on the record, so as to speak, as Omar would say, friend of the court laundering. Oh, okay. Thank you for that. Lily May, thank you for the 15. Not much, but I hope it helps. Love your emotion. Nice work. And that is more than enough. Oh my God.
Very nice.
You don't have to do anything like that. So anything is just generous. How about I say this right? Defragum? I'm not sure. Thank you for the $20 though. I appreciate it. All right.
Not sure.
All right, guys, I gotta take off for tonight. I need to get some sleep because I did not sleep last night and I was not feeling great before this stream. So if I don't, I'm gonna sleep until like the afternoon, I think.
Do you feel better now that it's done?
It's mostly just like when I get really like amped up, not even amped up about something, but I have to really focus hard on something and I'm working really hard. It's like I can't relax after that. So I finished this at 4 a.m. and then I maybe fell asleep for a couple of hours and I went to work, and then after work I was still just like so like just too tense to go to sleep. So I was like laying down for a while. That's it. Yeah. All right. Thanks, everybody. Appreciate you.
Yeah, I mean, it's been amazing seeing everybody file these motions to quash. Everybody, the community of you guys getting together to work on these things. It's been amazing to see. And of course, if you need anything, we're always around. Whether it's just to hang out on stream or read things or whatever, we're here to help out.
We should play Jackbox soon. Quiplash.
Yeah, let's do that.
It'll be fun.
And what am I supposed to do for the rest of the night? I don't know. Go to bed like me. I don't know, dude. Don DeVito, thank you for the 25. Phenomenal motion to quash Critters Long. Thank you very much, Don. I appreciate you. All right. I'm going to take off now and go to bed.
All right.
Thanks, everyone. Appreciate it. Bye.
Thank you for having us.